like to start off by welcoming you all and thanking you all for coming out tonight. I know a lot of us were marching in the rain for about 4 hours, so thank you very much for coming. I must say how lovely it is to see actually people in real and not see your faces on a screen as little squares. I am joined up here by a wonderful panel of experts from legal practitioners to civil society. Unfortunately, Michel Yonka-Agueta could not join us from Greenpeace International tonight, so allow me a few words to give a little bit of context on climate litigation. I think this conversation could not have come at a better time, when once again we must witness our leaders shying away from any accountability or responsibility. They are not addressing these pressing issues that cause people so much angst and worry. Simply put, and I quote here an inspirational speech from Maya Motley, Prime Minister of Barbados, when will leaders lead? Leaders must not and cannot fail those that elect them. We are already in trouble. The stability and balance we rely on is breaking. Those that have done the least to create the problem are the hardest hit. Ultimately, we will all feel the impacts. It is now unavoidable. Natural disasters are knocking on our door. They are not something that future leaders or future generations have to deal with. It has to be dealt with now. We have seen unprecedented floods in Germany, forest fires devouring Portugal, sea levels rising in the Pacific, and heat waves across the globe, and many more. Faced with such inaction, people have taken to the courts as a last resort to demand that their leaders take responsibility and respect their fundamental rights. Courtrooms are becoming key to address climate change around the world. People want their governments to come forward with policies and measures that reflect science. We have heard these numbers many times before, but I wish to repeat them here one more time to illustrate how litigation is becoming a global phenomenon. In 2017, there were 884 cases brought in 24 countries. As of 1st of July 2020, the number of cases has nearly doubled. We have 1,550 cases, more or less, filed in 38 countries. This growing tidal wave of climate litigation is driving a very much needed change. While climate litigation continues to be concentrated in high-income countries, we expect the trend to grow further, notably in the global south, and we can already list many recent cases such as Colombia, India, Pakistan, Peru, and many more. The background of plaintiffs is also increasingly diverse, with NGOs and political parties joined by children, senior citizens, migrants, and indigenous peoples. We expect climate litigation to increase in national and international bodies with respect to companies misreporting climate risks, governments failing to adapt to extreme weather events, and cases brought to enforce previous court decisions. A rise is also expected in cases concerning people displaced by climate change impacts. Climate litigation is compelling governments and corporate actors to pursue more ambitious climate change and adaptation goals. It is telling the stories of the people on the front line of climate change that are seeing their livelihoods endangered. Arguments used in front of the courts are a mix of science and human rights, notably including the right to life, health, food, and water. What is normally national jurisprudence is now going beyond borders. Legal practitioners are communicating amongst each other, and this panel is a great example of that. For this change to happen, we need the correct mix of voices, ambition, and action. Litigation is one of these venues where people of the planet can voice their fears, get their voices heard, and try to push their leaders to take action. I will not go further into any detail, and I will give the floor to our wonderful panelists. So to start, I would love to give the floor to Si Jong-yoon, that is from a Korean NGO, Solutions for Our Climate. Si Young, the floor is yours.
Hi. Thank you for the invitation. My name is Sejong Yoon with Solutions for Climate, and I'm counsel for the Korean climate litigation. The Korean youth climate litigation, in this case, we are representing 19 amazing youth climate activists in a constitutional complaint against the National Assembly and the President seeking a decision declaring unconstitutionality of the law and the presidential decree that sets the Korean greenhouse gas reduction targets. So in terms of climate litigation category, it's a case against the state on climate policy. On the factual side, we were arguing the NDC is insufficient to meet the Paris Agreement goals, so using reference points such as IPCC global reduction pathways, UNEP gap reports, or carbon budgets that we have calculated. And many analyses say that the current NDC will reach 3 to 4 degrees temperature increase if other countries also choose to do a reduction effort such as Korea's. On the legal side, we are arguing that the state has violated its obligation to provide protection of the fundamental rights, namely right to life, right to healthy environment, and especially right to intergenerational equality. One of the strategic points I would like to share today while we were preparing this case was how international climate litigations can be. Because the questions we are posing to the court is actually a new one. The court has not reviewed this type of questions before, such as intergenerational equality or human rights impact of climate change. And when answering a question that has never been dealt with or has no precedent on, the courts are very keen on looking into other courts and see how other courts have reviewed and decided on this issue. And because we had very helpful cases in Europe, including Netherlands and Germany, while our case was going on, we made sure our courts also view the legal analyses of these courts while reviewing their case. In addition to the comparative law aspect, we also reached out to the academia, constitutional legal scholars and environmental law scholars, and encouraged them to do more research and publication on this issue so that we have more robust basis when the court is trying to deal with a new question. Our case was launched in March 2020, and it has been a little more than a year and a half, and we have submitted 7 sets of written submissions. We are waiting for the court's decision to either have a public hearing or the final decision. I leave it there, and we sincerely hope this case sets a good precedent in the Asian region. Thank you.
Thank you very much, Sejong, and thanks for keeping it brief. I'll now, unfortunately, Janusz Bukowski from ClientEarth Poland couldn't join us today, but he was very kind enough to record a video for us about the Polish cases. If that could be shown. Excellent.
Hello, Janusz Bukowski, Polish office of ClientEarth. Thank you for having me. I'll speak about Polish climate cases that we filed between June and July this year. 5 cases that make up the whole legal intervention. All of them are similar as regards claims, and they seek a common remedy, being in line with Paris Agreement temperature goal by Poland. However, they are all being heard by different Polish district courts, and they refer to individual facts of individual people, 5 polls, 1 case filed for 1 person. The cases were filed by ClientEarth on behalf of 5 individuals. We have been trying to use a special provision of Polish law that allows an environmental organization to do that. These 5 individuals have 5 different stories. We have a farmer affected by droughts, losing crops, a person living in the forest plagued by storms, fires and forest degradation, a teenager who does not know what the future will bring for her, a person running ecotourism who is affected by a river flooding her buildings after intense rainfalls, an occurrence that did not happen a few years back. This is a simplification and summary, but these circumstances are complex. I'm not authorized to speak in details about them. those individual circumstances in our cases are important because we need to demonstrate to the highest possible degree the actual impact of climate change on the individuals. In legal theory, we don't fight here for climate as a common good, but as a good of individuals we represent. Against whom we file these cases? Of course, Polish authorities, Polish state, the only entity that has control over entire Polish emissions and that has obligation to protect citizens. Poland is considered laggard in Europe as regards climate protection, still planning to continue hardcore mining until 2049. The primary legal basis for the cases is the alleged violations by the Polish state of a number of Polish personal rights protected by the Polish Civil Code. These rights include the right to life, to health, to property, but we also are trying to persuade the court that there exists a right to healthy environment and stable climate. These personal rights overlap to some extent with well-established human rights, like the rights to life and to respect for private and family life protected by the European Convention of Human Rights. We argue that personal and human rights of our individuals are being violated by the Polish government's lack of action, acceptance of excessive emissions that are not in line with the temperature goal of the Paris Agreement. What should Poland do then to protect its citizens and to be discharged from liability, so to say, for consequences of climate change? The remedies sought, our demands in the proceedings are based on a fair analysis for Poland. The study found that in order to make an equitable contribution to meeting the temperature goal of the Paris Agreement, the Polish state must reduce national greenhouse gas emissions by 61% by 2030, below 1990 levels, and reach net zero emissions by 2043. This was an outline of what the cases are about, but what happened since we filed them in June. We have received only 3 answers to our statements of claims. We are currently working on replications. We are far from the hearings. In 2 cases, we did not receive answers to statement of claims because they were stalled by procedural issues. This is the beauty of our approach of independent cases. 5 cases, 5 stories, different courses of the proceedings and maybe different outcomes, but 5 chances in 10, very optimistically speaking, is more than 1 chance in 10. It's a benefit of having more than 1 case. Thank you very much.
Thank you very much, Jens, and hopefully we'll be able to have you here another time. Right now, I'd like to hand the floor over to Rebecca Thissen from the CNCD, Belgian Climate Litigation.
Yeah, thank you, Harriet. Hi, everyone. Thank you for being here. I know it's Saturday and it's raining outside and there was a march, so we're happy to have you here. First disclaimer, so my name is Rebecca Thissen. I work for CNCD 1111 in Belgium, and I do not represent the association that led the whole legal action in Belgium, but we did support from the beginning with my organization and many others this action, of course, and so I will maybe bring a more NGO perspective in all those climate litigation debates, which is also for us a really rising tool to accelerate climate action, so it's also maybe complementary with what others will bring tonight. So about the Belgian climate case, we call it Klimaatzaak ou l'affaire Climat in French. So it started in 2014, so quite a while ago, and it took really long time to get to the hearings, which was in March 2021. Belgium is a tiny country, but a very complicated one. So we had quite several procedural issues, notably on the language of the procedure. So it took really a while to get there, but we did. 58,000 people joined the action as co-plaintiff, which is quite historical and make one of the biggest actions around climate change in the country. So what did we ask? So we clearly asked the judge to recognize that Belgian climate policies were constituting a fault in terms of civil liability first, and a violation of human rights. Clearly, the Urgenda case from our neighbors from Netherlands were a big inspiration for us, and we worked closely with the lawyers from the Urgenda case, which helped to raise our own concerns. So we demand clearly more ambitious emission reduction goal for 2025, 2030, and zero emission for 2050, and, which is different from the Urgenda case, penalty fees as well. So that was a difference. So what did the judge say? The ruling came out in June. So the court did recognize that the Belgian authorities were civilly liable in view of their insufficient climate policies, and therefore were violating the human rights of all the Belgian citizens. So that was on that side a big victory for us, of course, but they didn't give us a right for the injunctions we were asking, and neither for the penalty fees. So we really won on the principle, but we didn't get any clear injunction to the 4 Belgian authorities. Yes, I said 4 because we have 4 climate ministers in Belgium. I thought you were tiny, but very complicated. So maybe some elements to rise. First, it's very interesting that the court considered the 58,000 co-plaintiffs as admissible. So this decision was really based on the Aarhus Convention. I think that's also a big part of the victory we made there. So the court also, as I said, decided that Belgium was civilly liable for its insufficient climate policies. But one good point about it, it was really pointing out the governance, the climate governance in Belgium. As I said, it's very complicated and it really doesn't work, doesn't function, doesn't help us to achieve our goals and be able to follow the European rhythm according to the Green Deal, for example. So, for example, this decision will really help civil society to ask for a new climate law, hopefully, I guess, because it's clearly stated in the ruling that this is one of the main issues that stops climate ambition in Belgium. Same as the Urgenda case, the court also stated that Belgium was violating human rights, notably the right to life and the respect for family life, so Article 2 and Article 8 of the Convention. But as I mentioned, the court did refuse to order injunction to reduce GHG gases emissions as requested, and that was a matter of separation of the power. So here we really see a different interpretation than the one was did in the Netherlands. So we can see also that although we are trying to achieve the same goals, it's really depending on the context and the reality of each country. I will stop here for now. Thank you, Arhid.
Thank you very much, Rebecca. And now I would like to hear from Lisa Göldner, just to my right, from Greenpeace Germany. Please.
Yeah, thank you very much. Thanks for organizing this great side event, and thanks for every single one of you for joining us tonight. Yeah, my name is Lisa Göldner. I'm a climate campaigner with Greenpeace Germany. And in 2020, 9 young adults from Germany filed a constitutional case against the German government. And this case was supported by Greenpeace Germany and also by German Watch. And those 9 individuals, they're already today directly impacted by the effects of the climate crisis in Germany. There is, for example, Sophie Baxen. She is 22. She lives on the island called Pellworm in the North Sea. Sophie and her 3 brothers are plaintiffs in this case, and their parents own an organic farm, and they see the impacts of the climate crisis every day. They've been hit by one year by droughts, then the other year by flooding and heavy rains. And Sophie is studying agriculture. She wants to take over the farm from her father one day, but there is she doesn't know what the future looks like because of sea level rise, because of the impacts of the climate crisis at the place where she lives. So Sophie and her brothers and other young adults, they decided to embark with us on that adventure and to take a risk and do something very courageous, which is taking the German government to court. So in 2020, we filed this constitutional complaint with Germany's highest court. And it was a constitutional complaint against Germany's Climate Protection Act. That's our climate law. And we argued that this Climate Protection Act, which solely contained a climate target for the year 2020, was insufficient to protect SOFI's and the other plaintiffs' basic human rights today and in the future. And in April of this year, we celebrated an historic win for climate justice. We won our case. So the court ruled that this Climate Protection Act of the German government is partially unconstitutional because it fails to draw a clear emissions reduction path from 2030 all the way to zero emissions. So the court ruled that this climate protection law has to be amended and it has to be brought in line with the German constitution. The court also ruled that by allowing ourselves too many emissions until the year 2030, today's generations are encroaching on the civil liberties of future generations, by shifting the reduction burdens to the future and to those people who will then be in charge of making political decisions. So they said, yeah, Germany has to reduce their emissions faster until the year 2030 and have a clear path how to become climate neutral. The court also ruled that climate protection is a human right. It has to be based on science, and Germany has to do their part in reaching the goals of the Paris Agreement. So this was really a great victory. It came as a surprise to us because it was quite far-reaching, and I'm very happy for the complainants to be able to share that victory with you tonight. And yeah, I think this win, it wasn't possible without all those litigation cases that have come before us and that are also represented in this panel today. And it wouldn't have been possible if it hadn't been for the strong climate movement led by young people around the globe, because it showed to the court that there is an interest in the public to deal with this kind of a complaint and to come to a decision. In this case. So I'm very happy to share that victory with you on behalf of our complainants. And I think we will speak about the implications of that ruling just in a few minutes.
Thank you very much, Lisa. I'll now turn to Lucy Greyl from ASUD, representing the Italian climate case.
Thank you, Harriet. Thank you all for being here tonight. And thank you for my colleagues for all the precedents that they have been setting also for us. The Italian climate litigation is a climate right case. It has been filled in June this year, so we are a very new case. Our case has been brought by 203 plaintiffs, among which adults, kids, and also non-profit organization. It's the first climate litigation that we have in our country. Our case is based on why we decided to bring forward, from a perspective of activists, of civil society, bring our demands to a court. We witnessed that the Italian state have been aware for so long about the threat that climate change brings towards its people, but has never acted strongly enough and never assume its responsibility to take action. And this not taking responsibility is representing a threat for the fundamental rights of its people. In Italy, we have a very peculiar situation. If we look at the data, for example, for the climate risk index of 2021, in the last 20 years, looking at the data, Italy is the 22nd country in the world for climate vulnerability. And we are the 6th country in terms of the number of deaths related to extreme weather events. So we are kind of a vulnerable country. Of course, we have more capacity, and we have much more capacity than other countries, and I will be back to it. But the action towards climate that the state has been taken so far is insufficient. It has been calculated that applying the climate and energy plan that is currently in act right now, we would reach only 36% of emission reduction in 2030 in respect with the levels of 1990. So we are well below of what the European Union asks us as a country to reach, which is already a level that is clearly insufficient to fight climate change. In our country, we do not have a climate law. We have only climate plans, strategies, but no law. We do not have a national carbon budget calculated by national institution. We do not have a national reduction targets that goes further what the European Union asks us to respect. So this is definitely for us something that is not sufficient to be tackling this big threat. Our legal approach is inspired, of course, and has been built on the precedent set by the Göldner cases. So we are mixing different level of fundamental rights related to national laws, to the European Convention on Human Rights, and also, of course, the obligation that Italy has as a signatory party of the Paris Agreement. We also have a case strongly based on sciences. If there is a lack of science data bringing from the national institution, we have relied on the support from Climate Analytics, a very important independent research center that helped us to build the scientific ground, our demands, and that calculated what would be the fair share for Italy in terms of emission reduction. So taking into account the historical responsibility of our country, its current emission, but also its financial and technological capacities, we reached to calculated a percentage of emission reduction that Italy should respect it to fully respect what the Paris Agreement foresees. So to keep it brief, what are the demands that our case brings? There are two main demands. The first demand, of course, is the recognition of the state responsibility and its responsibility because of its inaction and the threat this is causing to its people. And the second demand we are bringing, and we are asking the judge to pronounce itself above, is to ask the Italian state to reduce its emission by 92% by 2030. 92% is a very big number. We are well aware of it, but this is what science says. If we apply fair share and equity, this is what Italy should be doing and should aim to. As I said, we are a very new climate litigation. We are waiting for our first hearing next month on the 14th of December. So hopefully we hope that the justice system in Italy will move fast enough to tackle this situation. Thank you.
Thanks a lot, Lucy. And then I'd like to hand the floor to Jerry Liston, who works for GLAN.
Thanks, Harriet, and I'm very grateful for the opportunity to speak briefly about the Youth for Climate Justice case, which is brought by 6 Portuguese children and young adults against 33 European governments and is currently pending before the European Court of Human Rights. And the essence of their case is that the failure by these governments to adopt the deep and urgent emissions reductions needed to protect their futures and to hold global warming to 1.5 degrees is a violation of their human rights. The case was filed in September of last year, and within weeks of filing, the court responded to indicate that it had fast-tracked the case on the basis of the urgency and importance of the issues raised, and in a further indication of how impacted the judges were by the evidence of what the youth applicants stand to endure should global warming exceed 1.5 degrees. In their questions to the parties, the judges asked whether the applicants' rights under the prohibition, the article prohibiting torture, inhuman or degrading treatment was being violated. And this is very significant because no environmental case to date has been decided by the court in such a way as to find a violation of that provision. We've heard a number of examples of domestic climate cases this evening, of course, and I'll just briefly address the relationship between a regional case at the international level and domestic cases. We in GLAN decided to support this case on the understanding that the European Court of Human Rights, as a regional court, is particularly well placed to address a global problem like climate change. In particular, it can see that if all states adopt self-serving interpretations of their own fair share and exploit the ambiguity around principles like common but differentiated responsibilities, that it's not possible to hold global warming to 1.5 degrees. So our argument is that states must adopt mitigation measures consistent with more stringent measures of their fair share, and that's what gets us to the deep and urgent emissions reductions that are needed. And this ultimately, we hope, will set a standard in European human rights law that will then further enhance the efficacy of domestic climate change litigation in Europe and beyond.
Thanks very much, Jerry. And now I would like to hear from the audience, where we have Paul Moujol, that represents Notre Affaire à tous, and I'd like you to maybe talk a little bit about l'affaire du siècle, where I think you had some rather good news. The floor is yours.
Many thanks, Harriet, for the introduction. So yeah, can you hear me?
Yeah.
Okay. Yeah, I'm working for Notre Affaire à tous. I'm representing the NGO, and indeed we had the pleasure to experience a success in court after having filed a first application in 2018 against the state. So, of course, we relied heavily on the agenda judgment, and we applied it to the French legal system, and we demanded the French state to... I have to change the microphone. Is that okay? Yeah. So, yeah, we requested the French state to actually limit global warming to 1.5 degrees and, of course, to respect its own laws that it has enacted, which was not the case. So, in February 2020, the court recognized first the failure of the state to achieve its own targets by, it was a massive failure. So it was for the carbon budget. It's kind of a greenhouse gas reduction target for the period between 2015 and 2018. And yeah, so there was a massive failure by 2% every year to not achieve it. So it results in excess of 63 million tons of CO2. If you put into relation with the total carbon footprint of France, which is 400 million of tons, 400, yes, it's a lot. It's more than 10%. And so the court recognized that this is actually a breach of the law. There was a legal debate to know if respecting this sectoral this carbon budget is or not a breach of the law. So the court found this. We were really pleased that the court did it. And so the court then filed also, or issued, an injunction against the state very recently, 2 weeks ago, to reduce these emissions, to respect this carbon budget. So given that the state, after COVID lockdown, achieved 10% of greenhouse gas reductions, that the emissions were quite low, the state complied with this injection, but now the state has to remain below these levels. So the emissions in France, they cannot rise again anymore. If they rise again, then we can go to court and file an enforcement procedure in order to force the state to reduce its emissions. So this is a great victory politically, because the French state has no choice anymore. He has to reduce its emissions, and after having brought this petition, this case with the support of 2 million of French citizens, it's a very huge message that we're sending to the French state. In addition to that, I would like just to say some words about also another case that we brought in France, which is very different. It's against a corporation. It's based it's very similar, to a case that was also achieved a victory in the Netherlands, the Milieu Defensie case against Shell. So what we're doing is also not seeking the responsibility only of states, but also of a company, which is Total, a multinational oil and gas company, which has a carbon footprint which is as large as the French state, and that's also a very important issue. to also not only target state governments, but also companies. Thank you.
Thank you very much, Paul, and thanks definitely for mentioning the Total case as well. It is also of extreme relevance. I'll now ask Lucy Maxwell to briefly introduce the Torres Strait case, of which after we will see a video of the plaintiffs. Lucy, please.
Thanks, Harriet. Oh, there we go. It's on. Yes, just 2 weeks ago, 2 First Nations leaders from the Torres Strait Islands in Australia launched a legal claim against the Australian government in relation to its inadequate mitigation effort on the basis that it owes a duty of care to them to take reasonable and appropriate measures. And I'll not speak too much about the case, but let Paul and Pabai tell you about why they're bringing their case. So look forward to hearing from them right now. Thanks.
Thanks, Lucy. And now if we can maybe see the second video.
I'd like to pay my respects to the elders, past, present, and emerging. And I'd like to thank Father God to give me this breath of life.
Yeah, my name is Göldner, 53 years old. I'm from Saibai Islander.
My name Pabai. I'm from Buigo Island, which is located in the Torres Strait.
Saibai is about 4 kilometers on the coast of Papuan mainland.
We are the people of the council. We do know from the sea to the sky to the land. I'm looking at long-term conditions. If this issue won't be tackling, we don't want to lose our community under the water.
That's mainly affecting our livelihood, our cultural sites, and our reefs.
The roads, the houses.
We got water coming in through the river, fill the swamps up, and water coming through the drainage system, and we are living on this very narrow strip of land.
During this disaster, we do have infected by the cemetery has been infected by the water, and we remove our loved one. In our protocol system, we're not supposed to do that. Because when the loved ones is been arrested, that's arrested.
Saibai became less populated, like numbers have been going down, because most of the people have been moved out from there. Because of the climate change, there was no water, no better housing system for us. As I mentioned, like we are the environmental refugees on our own island.
We don't want to move the generation from our community and live, settle somewhere else.
If it doesn't going to work, well, we'll be underwater.
To the government's perspective, that'll be one of the key points that we are battling for our people.
We want them to help us to tackle the problems we've got.
This journey will be continuing to save my families, my people, my community.
Thank you very much, Lucy, for bringing that video forward. I think it really speaks for itself, and what people of the Pacific Islands are already confronted with, the disastrous effects of climate change. And I think this really has to resonate with us to take climate action, and our leaders to take climate action very seriously. Now I'd like to kind of make the session as interactive as possible, so we'll have a little bit of a discussion up here with the panelists, and I'll also ask the audience if at any point in time there is a question that you would like to ask, and we will also have a session of Q&A just after. So Jerry, briefly, what would you say is behind this surge in worldwide climate litigation?
Well, I think in almost all presentations we've heard this evening a reference to other organizations being inspired by other cases in other parts of the world, and I think a special mention is owed to the Urgenda Foundation, who pioneered this whole area of litigation initially. And I think it's cases building on other cases, and that was certainly the situation for our case, looking at other cases and what implications they might have in other jurisdictions. But more broadly, I think it's a reflection of the fact that simply no stone can be left unturned in the fight for literally the survival of our species and more. And law does have a role to play among so many other avenues to addressing the climate crisis, and that's really, I think, what is motivating this exponential surge in climate litigation around the world.
Thanks, Jerry. I think we can all agree that with the fundamental rights that have been violated in all of these cases, which I think is a common aspect of these cases. Lisa, could you maybe tell me, having a victor up here, could you maybe tell me what the consequences of your case are, and if you think it can be considered as a real victory?
Yeah, so as I said, the court ruled that Germany's Climate Protection Act was partially unconstitutional, and they also set a deadline until when it had to be or has to be amended, and that's by the end of next year. But that ruling came really at the right time, because we had federal elections in Germany in September, and it was obvious that climate change would become one of the issues heavily debated in the electoral campaign. So it took really only 1 week after the ruling for our Chancellor Angela Merkel to announce that they would amend this Climate Protection Act immediately, and for announcing an increase in Germany's climate targets. So I think in this case, the ruling, which was very clear and gave also a clear deadline until when that law has to be improved, and also the right timing, had really immediate political implications. So the German government amended this law. It went super quick. I've never seen any climate protection policy to pass that quick. I mean, when there is enough pressure, then things can go fast. So Germany's climate target for the year 2030 was increased. Before, it was a decrease of emissions by 55%. They lifted it to a decrease by 65% until the year 2030. And they also, now the target is for climate neutrality to be already in 2045. Before it was 2050. So we see a real tangible increase in Germany's climate ambition. Footnote obviously being that also these climate targets are not in line with 1.5 degrees, with the 1.5 imperative. And if you look at the carbon budget for Germany, then the carbon budget will already be used up by 90% until the year 2030. So I think these are still not climate targets that reflect intergenerational equity and the urgency of the climate crisis, but it's nevertheless an immediate response from politics to that. So we have this victory, we have real political consequences, and I also want to add a consequence that I see in the climate movement and in like the way that we discuss climate protection now in Germany, because I also think that that changed. I think the fact that there was this clear ruling that climate protection is a human right. Yeah, it's not just something that's nice to have, but it's our right as citizens that the government protects us and that they do sufficient climate action. I see that that gave a lot more courage and a lot more confidence to the climate movement. And yeah, we have a big discussion now on intergenerational equity that was obviously started by the Fridays for Future movement, but now having this backed up by the highest court in Germany, we talk differently about climate protection now after this ruling. Just to add a third consequence, obviously this ruling has consequences on other cases. I think in particular we will see that on the South Korean case, because the German Basic Law and the South Korean Constitution are quite similar. So this has an impact on cases around the world, and also there are already new cases in Germany that build on that ruling. It was followed by cases against federal states, for example, against Bavaria, and also Greenpeace Germany now launched a new case against Volkswagen. It's our first litigation case against a corporate target, where we use like argumentations from that constitutional decision on this case against a company, trying to push them for more ambitious climate targets in their business area. So I think we see here that climate litigation works. It also works if you don't win because you make a point. I want to emphasize that, I also lost already a climate litigation case, but we kind of had to lose that to get that win in the end. And it also further developed the way that we talked about climate protection, the climate crisis, and climate justice in Germany. So I think all of these cases, they build on each other. And I was lucky enough to have a case that was one that had such quick political implications. But I think every one of these cases are like one step further towards real climate justice.
Thanks very much, Lisa. I think we'd all love a victory in our cases and see it being implemented just after so quickly. But as you say, even if a case is lost, I think the whole campaign that is done around it and the awareness raising cannot go down as a loss. It's always something that's been won, and some awareness raising that's done around it. Before I go to Sijon, I was wondering if there was, at this point in time, any question in the audience that would like to be raised. Just there. Could you please go to the mic, if that's okay? We're not allowed to pass them around, unfortunately. Thank you.
Hi, everybody. I love the presentations. Thank you. I have a question for the members of the panel who've worked on litigation with children. And I wondered if you have thoughts about how that changed the kinds of arguments that you make and how you work with child litigants in a way that's different to adults, if you have any thoughts on that. Thank you. Thanks a lot.
I think on the panel we have Lisa and Jerry, if I'm not mistaken. Lisa?
So the plaintiffs in this constitutional case that I talked about are young adults from the age of 17 to the age of 32. I think that still counts as young adult. And these people, they have already been plaintiffs in other cases. So the first climate case that I worked on was also against the German government, and there it was 3 families filing a case against the German government. And we decided to take the next steps with the children of these families, because we wanted to make specifically that point on intergenerational equity, and we wanted to bring forward that argument that current generations cannot, push the burden of climate protection to future generations. The IPCC report made it pretty clear that we need rapid emissions reductions to keep global warming to 1.5 degrees. And the longer we wait, the more drastic measures we will need in the future. And that will limit the liberties of the young generations in the future. The longer we wait now with actions, the more drastic they have to be in the future. And that's the argument that we wanted to bring forth in the court. So that's why we decided to work with young plaintiffs. I mean, obviously it's sensitive. I think in all climate cases, and that's kind of speaking from the perspective of a campaigner, storytelling is key, right? I want to shift the debate. I want to shift the discourse. I want to talk about climate impacts beyond figures and statistics and numbers, but through the stories of these people. So obviously, we have to be quite sensitive when it's young people, especially when they're underage, about how much to share about their lives in public. But I'm always so at awe about their courage. And I shared with you the story of Sophie, and I saw her, when we had the first hearing in our first case, and she's grown so much, and she's giving all these great interviews now in international media, and I'm really at awe of their courage and how courageous they are to do something as, I don't know, as bold as taking your government to court. I don't know if that answers your questions, but that's the experience that I've made with working with these young plaintiffs.
Thanks, Lisa. Jerry, would you like to add anything?
Sure. I guess from a legal perspective, it's a simple fact that children and young adults stand to live longer into the future, and the climate impacts are projected to worsen and worsen into the future if we remain on our current trajectory. I guess opens up possibilities to make certain arguments. And for example, I think the reason I mentioned the court referring to the prohibition of torture, inhuman or degrading treatment, and one of the threshold criteria for the engagement of that article can at least be the duration of the suffering. And I think what the court is getting at is the fact that when you look at the devastating impacts of extreme heat in particular over the lifetimes of these youth applicants, that the cumulative harm that they will suffer over the course of their entire lifetimes, the court, I think, is suggesting at least the possibility that that meets the threshold for Article 3. So that's on the legal side. On the sort of practical side, I think the biggest lesson we've learned is just the importance of listening to the applicants. In our case, they've so much that they can input into the actual ultimate design of the case. There was a huge, in terms of the media coverage around the case, there was a lot of emphasis on their experience of the devastating 2017 fires, which killed over 100 people in Portugal. They themselves weren't directly physically harmed, although it was quite a traumatic event. Some of them lived very close to the fires. But they've always, for them, the lived experience of climate change is much more the heat waves that they've experienced in recent years, the rising heat extremes that the southern Mediterranean is experiencing. And that is something they've really pushed us to focus on in our, in terms of the framing of the case. And I think it makes the case much stronger. So that's just one of the sort of insights we've learned from working with this great group of children and young adults.
Thanks a lot, Jerry. I'll now turn to Sejong. In your opinion, I think we're all discussing here a little bit the relevance and the role that climate mitigation should take. So what do you think, do you think litigation is the answer to increasing ambition worldwide?
I think it's not the answer, but it certainly is an answer, because it really fits the role of the court as the protector of rights. So what we see with the insufficient climate policies is basically political failure. The majority has made laws, and based on those laws, policies have been made, but they're insufficient, and it's driving us into a greater danger. And when these failures result in infringement of rights, that's when the courts come in. That's what courts are supposed to do. So that's why litigation is certainly an answer to climate crisis. And like Lisa mentioned, you don't have to win the case to make an impact. For example, while our Korean case was ongoing since March of 2020, October 2020, the president announced net zero 2050 target as the national goal. And then a carbon neutrality act actually was legislated and replaced the law that we were disputing. And last month, NDC was enhanced from 24% from 2017 into 40% from 2018. So these are progress. And while it's definitely cannot be solely attributed to the climate litigation, but I do think it really had an influence in the developments to this direction. Because existence of a legal challenge or a constitutional challenge to a law or a policy really creates pressure towards revisions and enhancement. But our case still stands because the new law and the new policy is still insufficient to go anywhere near 1.5 degrees. And that's why we continue to do so. But it's not the answer because of the court's role. We can ask the court to declare that the policy is insufficient and it's infringing on the rights. But asking how much is sufficient? What's the percentage? What's the right level of protection? I think that's a question that the court may not be well equipped to answer. And there are questions whether courts should be answering those questions. And these are the area that needs to be filled, again, back to the political process and also campaigns outside the court and the discussions.
Thanks, Sejong. Would anybody else have a question from the audience? Oh, wow, that's lots. I'll just take one right now. Yes, just there.
Ian Lumley. I'm with Friends of the Irish Environment, obviously, from Ireland. And we took a successful legal case to the Irish Supreme Court. You always got to remember, you can lose in a lower court first, but you keep on at it. We lost in the High Court. And we struck down the Irish National Mitigation Plan last year as not being compliant with the 2015 legislation that was introduced in Ireland in conjunction with the Paris Agreement. So that legislation has now been superseded by a new Climate Act and a new climate mitigation plan that was announced last week. So our focus is now going to be on the enforcement of that. So that's the first interesting question. If you have a plan that actually has targets, the issue then, if those aren't being met, where you come in enforcement. We had a second case where we had quite a different experience. This was a case against the building of an additional runway in Dublin Airport, which would obviously increase climate impact. And we lost that case in the High Court. Our legal advice was that we didn't have grounds for appeal to the Supreme Court. It's quite a tough barrier to get to the Supreme Court. The grounds have to go through a separate process. But the judge did something very interesting in refusing our case. He went into considerable expostulation on the right to a healthy environment. So we're going to use that principle in other potential litigation, because we're also looking at litigation on nitrate, pollution of water, and air pollution. So obviously the focus of your expertise here before us this evening would be on climate litigation, but there's a much wider front of litigation emerging globally on air pollution and on water pollution. And I'm just asking if you're coming across any precedents that are emerging in those areas, air pollution and water pollution cases, that have been won on the right to a healthy environment, that can then be used as a precedent for climate litigation cases. Thank you.
Thank you very much. Is there anybody that would like to take that question? Has nobody won a case or fought a case with air and water? No? Maybe Lucy? Something's whispered in my ear that Lucy Maxwell might know something about it. Sorry to put you on the spot.
I think this is still on. Yes, Paul, did you have a response?
In France, so the Supreme Court, Administrative Supreme Court, forced the state already in 2017 to comply with the air pollution regulations, the European ones, and it set indeed a precedent which was heavily relevant for the climate case that was also brought before the Administrative Supreme Court. So the French court and the French judge, they found very similar principles in the climate case as in the air pollution case. So this was really helpful indeed.
Thanks very much, Paul, for saving the day. Sorry?
Is it? Yeah.
Yes, sir.
I just have a question, if I may.
Why not?
If it's possible, for the German case. Since you recognize that actually the achievement is not enough to limit global warming to 1.5 degrees, right? It's the applicants are then, in your view, not sufficiently protected from the global warming impacts. Would you consider going again to court, given that the newly enacted targets are still not enough in your view?
Yeah, certainly. But I think not right away, because we just recently had federal elections in Germany, where there are coalition talks going on at this very moment. So at this point, I cannot say what future climate politics will look like, and I see an opportunity for yet again an increase in climate targets. And also, like, there is a timeline from the court that was given until the end of next year. So I think within that time period, no. But I think if at that point German climate politics or German climate targets are still not in line with what is needed, with 1.5, what is needed to protect the plaintiffs' rights today and in the future, then obviously we would consider continuing.
Thanks, Lisa. Rebecca, do you think you could tell us briefly about maybe a little bit weaknesses and strengths of litigation, in your opinion?
I can try, yes, briefly. I think many things has been said, notably by Lisa Essayong right now, but I can try to sum some things up. About the weaknesses, first it's important to remember that each context is specific and therefore the realities, opportunities and weaknesses are different too, but maybe there are like some common trends. First, a big weakness of climate litigation is, of course, that it can be very slow. Not in your case, I agree, but for example, in Belgium, it took us 6 years just to reach the hearing part. So it can be also very frustrating and maybe a bit demotivating to wait that much time. It can be also very expensive, and that could be really a starting blockage to go further. Maybe on the more legal aspect, we can also see often the difficulty for plaintiffs to prove their legal standing to bring proceedings. So that can be a very heavy burden of proof, but which is more and more easy to avoid, notably thanks to the IPCC report and the more and more accurate science-based explanation on climate change, but still that can be a kind of an obstacle to go to litigation against a state or a company. Another challenge is also the difficulty to establish a causal link between the damage and the harmful behavior of the defendant, whether it's a state or a company. Proving that specific greenhouse gas emission of a state or a company are causing the effects suffered by the plaintiff are not always easy. Attribution science for this is very crucial and is helping more and more to make those links, but it can also be very a serious obstacle to succeed in climate litigation. The matter of separation of power can also be an issue. We saw it in Belgium. We won on the principle, but we didn't get any injunction. So then we can maybe be a bit frustrated with what would be next and what would be the effectiveness of this ruling. The matter of effectiveness and implementation are of course crucial, and I could go on and forth. And of course we have our issue in the global north, but in the global south is really different, mainly also because of matter of security. Our environmental defenders are really at risk, and so of course going to court might be another life threatener than we could face in Belgium, France or Germany. About the opportunities, maybe on a positive note, I think one big step that climate litigation has done is make victims visible and make responsible known, which is really crucial in the climate change discussion. So that's, I think, really an amazing step forward. Then many things were already said on the communication awareness tool that it can bring, the mobilization of public opinion around climate change. So I think it's really important also to distinguish what we can achieve in the court. So of course, hopefully a victory, but also legal evolution and so on and so forth, but also outside the court. We talk about the German case, but it's also really, really interesting to look at what happened in the Netherlands after the agenda case, mainly, for example, a climate law, a climate plan, and climate roundtables to discuss about this transition. So these are many political consequences that are very tangible and that could really help move the different action on climate change forward. One other really interesting part about climate litigation is the objectivation of the debate. We are not so much talking more about the economic or political opportunity to take one or other action about climate change, but really about the science-based opportunity to do it or not, which is, of course, crucial. A last point maybe that's also very positive is the role in rebalancing the various forces at play. So we know that states and companies have much more money, much more power to make their ruling and make their way into whatever they want to do, while citizens and NGOs have less ways to do it. And going to court helps to rebalance the situation and make things more equal in front of the judge. So that's also, of course, very helpful. I'll stop there.
Thanks a lot, Rebecca. Is there another question at the back there? Yeah, one of you too. Please.
Thank you. It could be a very quick question, which is simply, what next? But my sort of subtext that would be, last night I heard about the non-fossil fuel proliferation treaty. And might there be litigations to phase out the licensing of new fossil fuel production, which is all about, you know, the gap now, not just between climate targets and country targets, but country targets and delivery. And then in terms of this COP process, there seems to be a lot missing from COP. There's no talk of international travel. There's no talk about the shared responsibilities for dealing with international trade. The devil in the room of the likes of the Energy Charter Treaty that allows companies to sue governments to stop climate change rather than what you've talked about, which is the other way around. I mean, how do you see we overcome trade, get COP to really work and include international travel and stop giving licenses to oil drilling?
Thanks a lot. That's a very full question. Would there be anybody that would like to give it a first stab? And then, Jerry, please.
Yes, so in our case, we address not just the territorial contributions of states to global emissions, but also their contributions to non-territorial emissions, including consumption-based contributions through imports, so the international trade-based contributions of the kind you're talking about. And also, similarly, the case addresses exports of fossil fuels and the obligation of countries to phase out exports. And of course, the production gap reports that I think you referred to are extremely helpful for that argument. So, yeah, we've seen cases, the Emilia Defensi case against Shell, and other cases focusing on the broader footprint of companies, and I think litigation against states is also moving in that direction. I know the one other case pending before the European Court of Human Rights against Switzerland also focuses on non-territorial emissions. So I think it's a case of now and not just next.
Thanks, Jerry. Is there somebody else that would like to say, John, please?
Yeah, I think those approaches is going to be really case by case, and I could share one case that we did 2 years ago. It was a coal power plant in Indonesia that Korean Exim Bank was trying to finance. So we brought in plaintiffs from Indonesia and filed an injunction against the Exim Bank not to enter into a export credit agreement. And legally speaking, it's a very difficult case, but we just brought it just to send a message. And with the accumulation of the right cases, when the time goes by, I think those new legal approaches can make a breakthrough, just like we saw with the Royal Dutch Shell case. So with oil and gas development and international trade, I think it will be more case by case, a diversified approach compared to challenging climate policies by the government.
Thanks, Yijong, and I think Rebecca would like to add something.
Yeah, I totally agree with what has been said. I also think it will be a rising trend, notably on, for example, state aid that we're giving to polluting companies during COVID. We also see that's something that could be arguing in front of court. So I'm sure that climate litigation could be a very powerful tool to make also those polluters pay and stop those contracts that are just fueling the climate crisis. On the other hand, you make me think about something that I didn't mention. You talk about the COP, about what we discussed at the COP. We talk now a lot about mitigation, but there are other two pillars of the Paris Agreement we didn't address yet, which is adaptation and loss and damage. Climate litigation could be also very helpful to increase those two subjects and make them more concrete. Adaptation, we already saw a really interesting case in Pakistan to make adaptation measure more ambitious. But loss and damage is something that is barely addressed, if we can be honest, in the negotiation right now. And I think climate litigation could be really an extra leverage to make the ask of the most affected countries real, and also making a link with climate displacement, which is an actuality or reality for many and more people every year, but still is not discussed anywhere internationally. So I think climate litigation could be also a really good tool about this, and we saw already an interesting case in New Zealand around that. So I'm excited to see the next steps.
Thanks, Rebecca. I hope that answers your question. I think we have another question here from this sir on mic 2.
Yes, thank you. A comment and a question. Comment, I'll be very brief. I don't know if any of you were in this room this afternoon, but about 2 sessions ago, another group of legal experts representing the Paris Implementation Committee, part of that process, part of the UNFCCC, were explaining that they had, over the last 2 years, very proudly worked out the rule book to implement the Paris Agreement, which was entirely based, they kept emphasizing it being facilitative, it would not involve any sanctions, it was all meant to be very cooperative, and they didn't want to make themselves unpopular, a word that was repeatedly used. At the end, I stood up and asked a question, so how do you actually expect this is going to advance the ambition of any countries? And actually the co-chair explained that the Paris Agreement legally does not require you to, in fact, it requires you to submit an NDC, but doesn't require a country to, in fact, achieve its NDC. And these were the parameters they were working under. So if any of you are in any doubt about the value of what you're trying to do using a different legal processes, that conversation, I'm just still trying to equate the two discussions with exactly the same, different groups of people sitting in exactly the same room, a couple of hours apart. I'll cut to my question. I was struck by your comment, a colleague from Korea, about whether courts could set a target or the degree. I'm wondering to which degree, as countries move along, I'm from Canada, the Canadian government recently actually passed a law, not with as much teeth as it might have, but a law enshrining a net zero by 2050 as a goal. If that is going to sort of have its own impact on the kind of cases that are being brought in various jurisdictions by setting a much more specific target against which courts might start to find governments, the adequacy of governments' plans. And just one last little coda, I'm very struck by the fact that, are you seeing more cases where IPCC evidence gets brought in and has legal standing and recognition rather than just a scientific observation, but something that actually has force and weight in the legal systems?
Would anybody like to address that briefly? Please, just leave me 1 minute at the end to close. Really.
Oh, sure.
Thank
sure.
you.
Yep. I can just make a brief comment on the IPCC. We use and rely on the IPCC a lot because the government signed on it, and we try to limit our factual basis on the IPCC and not much else, because we wanted to really reduce the debate on the factual basis. In that sense, I think has become a very useful source.
Thanks. And thank you even more for keeping that super brief. I've got this big clock in front of me and the time is running by. I realized actually at the beginning that I didn't introduce myself. So I'm Harriet Mackaill and I work for Climate Action Network Europe, which is an umbrella organization in Europe of about 180 members. And we work on a myriad of things, and I work particularly on climate governance and human rights with all of these lovely people up here. So I will not try and summarize all of the cases that we have heard from today. I think I'll just keep it very brief and say that I think we can and we need to expect more litigation coming in the next years to come, as I think we all know that the next decade is the most important. And once again, as I mentioned in my opening comments, we are witnessing a lack of responsibility taking and a lack of accountability from our leaders. So if litigation is what we need, although it be a last resort, because I think we would like to see some policy and measures actually that would be in line with science, we will be carrying on litigating. And I think companies and states should be looking out and keep it in mind. I'd like to thank you all for coming out. I know it was raining, I know some people have been marching, it's wet, it's horrible, it's Saturday night. So thank you very much for coming and for all of your interesting questions.